Now, Martha, contracts govern here in these relationships, but obviously this crisis was not foreseen when these contracts were negotiated originally. No one anticipated COVID. So what does that mean for consumers or for suppliers? And would any of the things that are happening right now, including, the storms in British Columbia, would this constitute force majeure under a contract?
That's a good question. And there's no doubt that a lot of ink has been spilled in the legal sector around the issue of force majeure clauses, which are also tied to the concept of contract frustration. Both entail the notion that the contract or certain parts of the contract cannot or will not be fulfilled under particularly urgent circumstances. So generally speaking, a force majeure is an event that cannot be controlled or anticipated necessarily by either party. So it's an unexpected event that prevents someone from doing or completing something in respect of the contract that they have agreed to do. And usually we think about emergency issues such as what are often called acts of gods, natural disasters, floods, hurricanes, and acts of people like riots, strikes, wars, etc. And so whether or not the COVID pandemic fits squarely into a force majeure clause has been the subject of much discussion. I would say that the pandemic itself would not constitute sort of an excuse under a force majeure, but potentially the implications of the pandemic would allow for a party to exit an obligation if it falls under their force majeure clauses. For example, what has the pandemic caused or not caused to happen that is preventing a party from performing the functions? As we talked about earlier, as George mentioned, labor shortages, for example, or a goods shortage, or if you are supported by an entity above or below you in a supply chain, and one of them is having struggles with their ability to procure goods or services. So potentially the impact of COVID might constitute a force majeure, but it is unclear that the pandemic itself would be. And so when we're looking at working around the problem or how entities should deal with this moving forward, it's really about finding practical commercial arrangements that would allow them to identify additional sources of supply, for example, or creating opportunities to renegotiate the contract if required.
Exactly. That's sort of what I want to ask you about now, George. How do purchasers and suppliers deal with these delays without necessarily having to resort to a legal dispute? Since these supply contracts, these relationships are usually not one-offs, and suppliers and purchasers rely on one another. How do you resolve these things without having to go to court or an arbitrator?
Well, I think paramount importance here is that there's a very strong incentive, especially while COVID pandemic conditions remain in effect, to maintain those relationships. Because frankly, another part of the supply chain story is that not only is it hard to get goods in and out of country, it's hard to get people in and out of countries, right? And supply chains run on people, right? You're not going to go buy a huge order from a factory you've never seen or toured or assured yourself that the quality controls are correct. So if you're having troubles with your supplier, you're not going to go run off and find an alternative source of supply. You're constrained in your ability to do that. So the incentive is really to come to some sort of an agreement. And a lot of players, everybody's aware of what the conditions are, right? Everybody knows that it's hard to move the goods and there's shortages. So open communication is absolutely key. Some of the things that we've seen in the past months, a supplier might put its various customers on allocation. We can only deliver you so much product within a certain amount of time in light of the various constraints. We've also seen some suppliers prioritize some customers over others because some relationships may be more important to the bottom line than others.
Now, we've got about a minute left, George, but some purchasers have been imposing so-called fines on their suppliers for failing to deliver things on time. What can you tell me about that?
So typically in a contract, at the time of negotiation, you can predetermine an amount of what's known as liquidated damages for a failure to deliver on time. So that might be a certain sum of money that is paid for every day that the delivery is late. We typically see these types of liquidated damages clause in two scenarios. One is where you have a very, very powerful purchaser, big national, international chain will have the purchasing power to force smaller suppliers to accept these liquid damages clause.
George,
Another
before you get
place-
to the second one, we've got to go to commercial break, but I want you to finish that up after that break.